Good morning and welcome to season 3 of the Brodie's Banking Academy. This is the first session in season 3, and today we are going to be chatting through the National Security and Investment Act, NSIA, and the impact that the NSIA has on Scottish financing transactions. Today you have got myself, Thomas Horton, an associate in the Banking and Finance team, Jake Stephen, a solicitor in the Banking and Finance team, and Donald Campbell, a trainee solicitor. And today we're going to be covering a number of aspects of the NSIA, touching on what the NSIA actually is, how it is relevant to Scottish banking deals, and also touching on the notification process itself, before touching on the new Moveable Transactions legislation, and then finishing up with some questions. So without further ado, I'll pass you over to Jake, who will give us a bit of commentary on the NSIA Act itself.
Thanks, Thomas. Yes, hi everyone. So as Thomas mentioned, today I'm going to kick off by talking about the National Security and Investment Act, or NSIA, as you can see, we've abbreviated it on the slides. And I'll start off by giving you a brief background to the Act, moving on to highlight some of its key provisions, and then come back later on to discuss the impact of the new Moveable Transactions Scotland Bill on the application of the NSIA in Scotland. So starting with the Act itself, you can see there from the slide, it established a standalone statutory regime for the government's scrutiny of and intervention in acquisitions and investments in certain sectors of the UK economy on the grounds that it poses a national security threat. The Act came in and replaced the government's previous powers under Part 3 of the Enterprise Act 2002. So moving on to the background, I've got a nice slide there for you, detailing some of the key dates. So it all kicked off back in October 2017, where the Department for Business, Enterprise and Industrial Strategy, or BEIS, published a green paper summarising the outcome of the government's review of its existing powers to scrutinise transactions on the grounds of national security under the Enterprise Act. You might all recall that this was the beginning of some increased tensions as well between the East and the West, which ultimately led to the China trade war. So the Green Paper concluded that the government's powers needed updating. The proposed reforms to improve the identified issues included expanding the government's power to call in a broader range of transactions by establishing a new voluntary notification regime and introducing a mandatory notification regime to catch all foreign investment into certain parts of the economy which the government deemed a risk to national security. The next key date that's worth noting is July 2018, where the BEIS published a white paper. This set out how the government planned to address the risks which it identified in the Green Paper in more detail. However, following many delays presented mainly by the COVID-19 pandemic and some increased tensions between the East and the West, the government later concluded that the proposals contained in the Green Paper did not go far enough. So the government went back to the drawing board to rethink its strategy. And you can see there from the protracted timeline that it took up until January 2022 for the Act to come in full force. So now that we've looked at the background, I'm just going to discuss some of the key features of the Act. The NSIA regime applies to transactions that involve the acquisition of a specified level of control over certain qualifying entities or assets in the UK. The relevant NSIA triggers are set out on the slides and can be found in sections 5 and 7 to 12 of the Act. An example is the first one there on the slide, the acquisition of votes or shares in a qualifying entity exceeding a threshold of 25% or 50%, or reaching or exceeding a threshold of 75%. Thomas will discuss this particular trigger in a bit more detail later on, but it's worth bearing this one in mind from the outset. A qualifying entity, as you can see, we've underlined that there, is any entity other than an individual, whether or not a legal person, which can include foreign entities if that entity carries out commercial activities in the UK. A qualifying asset includes land in the UK or other tangible or intangible assets such as intellectual property. So clearly these wide definitions will inevitably catch a lot of transactions in the UK. Another main feature of the NSIA is that it provides for a dual notification system. So we've moved on there to start off with the mandatory notification system. This regime applies to notifiable acquisitions, where this involves a transaction where a party gains certain levels of control in a qualifying entity, such as the trigger levels that I've mentioned earlier. And the qualifying entity operates in one of the specified high-risk sectors of the UK economy. I'll come back to discuss these sectors in a bit more detail on the next slide. If we could just go back one. Such acquisitions must be notified to and cleared by the Secretary of State in accordance with a prescribed procedure before that acquisition can take place. The process is all online, and we'll cover that in a bit more detail later on as well. Acquisitions of qualifying assets aren't currently subject to the mandatory notification regime. However, this might well change in the future. A notifiable acquisition which completes without first being approved by the Secretary of State will be found to be void and have no legal effect. And a person who completes a notifiable acquisition without first obtaining prior clearance will be liable for fines up to £10 million or 5% of a group's global turnover. There's also the risk of imprisonment, and the Secretary of State can impose certain conditions on a proposed transaction that they weren't notified about. So clearly, the mandatory notification system is not to be taken lightly. So we could just jump to the next slide, please. So as I mentioned, a qualifying entity is within the scope of the mandatory notification regime if it carries out activities in one of the 17 sectors which are listed in the schedules to the NSIA notifiable acquisitions regulations. These are set out in the slides there. And a very good example, and one that's quite topical at the moment, is energy, given how important this industry is for national security in the UK. The BEIS has published further guidance to assist businesses and investors to assess whether their proposed transaction might be within the scope of the mandatory notification regime. And Thomas will cover this a little bit later on. The mandatory notification regime is then supplemented by a voluntary notification regime, which under this framework, parties are encouraged to voluntarily notify trigger events to the Secretary of State. This approach widens the Secretary of State's net by putting the onus on parties to inform the government whether their transaction may have any national security implications. Given the complexity of this task and to help inform their assessment as to whether a voluntary notification should be made, parties can refer to the statutory statement under Section 3 of the NSIA. This sets out how the Secretary of State expects to exercise its calling powers in practice. A trigger event that falls within the voluntary notification regime can be implemented without first obtaining clearance. However, the Secretary of State does reserve the power to call in a non-notified trigger event for review. They have the discretion to do this within 6 months of becoming aware of the relevant trigger, provided the call-in takes place within 5 years of the acquisition occurring. So going on to discuss the call-in power itself, the Secretary of State has the power to call in any in-scope transactions for a full national security assessment, whether it has been notified about the acquisition. This is set out in sections 1 to 3 of the NSIA, as you can see from the slides there. It is, however, worth noting that an acquisition of an entity outside any of the 17 key sectors are unlikely to be called in, since the likelihood of the national security threat arising in these areas is much lower. Despite this, parties may still wish to notify the Secretary of State about their proposed transaction to avoid the risk of it being called in. The call-in power itself is subject to a two-limb test, which we've set out on the slides there. It may be exercised where the Secretary of State reasonably suspects that a trigger event has occurred and that the trigger event has given rise to or may give rise to a national security threat. In practice, the call-in power is exercised by giving a call-in notice. So just to discuss this very quickly, as you can see, if we could just jump to the next slide, please. As you can see, a copy of the notice must be given to the acquirer, the qualifying entity, and or any relevant third parties that the Secretary of State deems necessary. So this would include, for example, a seller. And the notice itself must include a description of the relevant trigger event and state the names of the persons to whom the notice is given. If a call-in notice is served following the, sorry, we could just move to the next slide, please. If a call-in notice is served and following the completion of the assessment period, the Secretary of State must either clear the trigger event or make a final order where a national security risk has been found to arise. The final order will impose some remedies that the Secretary of State deems fit. And as you'll see from the next part of the slide, a decision to impose a final order may be taken where the Secretary of State is satisfied on the balance of probabilities that a national security risk has arisen and reasonably considers that the provisions of the order are necessary and proportionate to prevent, remedy, or mitigate the identified national security risk. A final order may also include conditions requiring a person to do or refrain from doing certain actions. And a recent example that we found published on the government's website was an order which contained the condition for a qualifying entity to continue to fulfill its obligations under some critical supply contracts to the Ministry of Defence. So really, we can't stress enough the importance of due diligence early on in the process, particularly in a Scottish banking transaction. And I'll now pass you on to Thomas, who will discuss this particular point in a bit more detail.
Great, thanks, Jake. So yes, I thought it might be useful to give a few examples and talk through how we're seeing the NSIA actually impacting on Scottish banking transactions. And it's largely revolving around a difference in security law between English and Scots law and a concept called equitable charges. So if we were doing this in person, I'd imagine there would probably be a few blank faces. So I thought it might be quite useful just to chat through exactly what an equitable charge is and why they don't work from a Scottish perspective. So on the slide there, we've got a few notes and a bit of a refresher. But put simply, in English law, you can have an equitable security and a legal security. So an equitable security would give the security holder a contractual right, whereas a legal security would give the security holder an absolute legal right. But there isn't that same concept in Scots law, that concept of equitable charges. And as we've noted on the slide there, in order to take effective fixed security, possession of an asset is key. So what that means in practice is a security holder needs to be able to take possession of an asset for a Scots law fixed charge to be competently granted. Without it, the parties can enter into a contractual arrangement that binds the borrower, but this would not amount to effective security and would not bind any future liquidator of the company. And I think share pledges are actually a very good security to show the differences in English and Scots law and around this equitable charges concept. I think for one reason being one that share charges are quite prevalent in the financial transactions we're involved in, but they also give a really good example of this equitable charge concept and how it works between English and Scots law. So on the next slide, we've put up a bit of a worked example of the mechanics of taking share security in English and Scots law. So imagine you're entering into a financing and you grant a share charge. The share charge would usually be over shares in the borrower, such that the funder can exercise control over the borrower should the borrower default. So for an English law share charge, what would happen there is the share charge is signed, it's dated at completion, and alongside that share charge, you have a stock transfer form and a share certificate. And those would be signed, but they crucially would not be dated. And that's because of the English principle of equitable charges. Whereas because Scots law doesn't recognise that concept, that same process of signing and dating your share security and signing the stock transfer form and share certificate would be carried out. But then critically, those share charge ancillaries, so that stock transfer form, that share certificate, they would then be dated and a formal transfer of ownership of the shares would have occurred such that the register of members of the company would then be updated, showing the security holder or their nominee as the sole shareholder in the company whose shares have been pledged. So Section 8 of the NSIA deals with control of entities, and I've put up a few lines on that in the next slide, a few subsections around subsection 2A and 5A. So there, 2A it covers what we call the shareholder trigger, whereby the shareholder trigger occurs when there is an increase in the percentage of shares in the acquirer holding in the company to more than 25%. And that second trigger there, the voting rights trigger, is where there has been an increase in the percentage of voting rights that the acquirer holds in the company to more than 25%. So on the face of it there, for an English law share security, neither of those triggers will have occurred, because the shareholder trigger won't have occurred because there's been no formal transfer of ownership of the shares. And because there's been no formal transfer of ownership, the voting rights trigger will also not have occurred. Of course, in Scots law, because we don't have that concept of equitable charges, that shareholder trigger will have occurred because of the formal transfer of ownership. The voting rights trigger, more likely than not, will not have occurred for a Scots law share security, and that's because in the market, what we're seeing is share security being drafted such that the voting rights and dividend rights associated with the shares are retained by the pledgor until such time that a notice is given by the security holder that the security is being enforced, and only at that stage will the voting rights voting rights trigger, have occurred. So on the next slide, we've noted down the potential 3 triggers that funders really need to be aware of when entering into share security. So we've mentioned the shareholder trigger and the voting rights trigger in relation to English and Scots law security, but we've also noted a third trigger there, a further shareholder trigger, which might potentially occur on enforcement, whereby the security holder takes the decision to transfer ownership of the shares to a third party. And that will be a separate trigger. What's key to note here is that each instance, so each shareholder trigger, voting rights trigger, is a separate trigger, and each separate trigger event requires the prior approval of the UK government. And I should also note here as well that while we've been chatting through this being a Scots law point, it's also important for English law share security to note these trigger events as well, because the notification requirement is on any transfer, and so it does need to be a live concern outside of Scotland, given the enforcement mechanics of an English law share charge, such that on enforcement, that shareholder trigger would occur, that voting rights trigger would occur. So you might be thinking, how does this interact with the NSIA Act itself and the guidance which Jake mentioned around the Department of Business, Energy and Industrial Strategy guidance? So on the next slide, we've put down some quotes there from the BEIS, because I think when certainly I've been coming across these issues, you would think that would share security be caught by the Act, because as Jake mentioned, what the NSIA allows the government to do is to scrutinise and intervene in certain acquisitions that could harm the UK's national security. And I think on the face of it, you might be wondering, how does entering into a financing transaction and granting share security, how could that be at odds with the UK's national security? And against that question, against the backdrop of that question, and lobbying from several professional bodies, including the City of London Law Society, the BEIS issued some guidance in July of 2022 to discuss whether or not share pledges are caught. Now, the guidance is quite English focused, but it does mention share security specifically. And what it notes is, whilst the grant of a security over shares could create an equitable interest in such shares, such interest would not appear to grant any control over such shares, as referenced in section 8.1, and unless or until that event which could provide control happens. So that's catering to the English law point around equitable securities. So what they're saying there is, until that shareholder trigger occurs, there's no NSIA Act implications. But what the guidance did go on to state specifically is the creation of a share pledge over shares in a qualifying entity of a specified description under Scots law, where title to the shares is transferred to the secured lender or its nominee, would require prior notification and clearance from the government. So it's pretty clear there from the guidance that the Act does apply to Scots law share security, and so something that Scottish lawyers, as well as lawyers south of the border, need to be very aware of. when entering into financing transactions. So you might be wondering where we are seeing issues arising in our transactions, and really we're seeing it in relation to the energy sector, be that in renewable energy transactions or also oil and gas transactions. And we're also seeing it in relation to telecoms transactions, which we see as falling under the communications and data infrastructure sectors. And on the next slide, pardon me, on the next slide, sorry, if we could go on to the next one as well, please. You might be thinking how we would respond, or sorry, how the market has been responding in relation to the NSIA and its impacts on financing transactions. As we've noted on the slide there, really it's been with an absolute abundance of caution, really. And I think a lot of funders taking an approach of not really wanting to be the first mover, really. And what this has resulted in is a lot of funders taking unperfected share security and relying on underlying floating charges and the rest of their security package. Now, just for clarity, unperfected share security would be the English law plan of action, whereby the share security is signed dated, but the stock transfer forms, share certificates are not dated, and the register members not updated. So no formal transfer of ownership. And I think a reason for a lot of funders taking that plan of action is really around the potential delays, which Jake touched on briefly, and Donald is going to give us a bit more information on, the potential delays to completion that the approval process could have. And I think as well, the risk of calling in, which Jake touched on. But I think there is also a distinct risk in progressing with unperfected share security, as it opens funders up to a concept called the hardening period, whereby the security could be challenged. So that's a real issue that funders need to be aware of going forward. And I think another reason for this abundance of caution really is because of the sectors themselves, the 17 sectors, being quite vague as to what they would pertain to. So, for example, would a key infrastructure project like a hospital, community nursing unit, a school complex, would that fall under critical supplies to government? We're just not really sure yet. And so I think what's being borne out more in the acquisition market rather than in funding, but I think what the market has been seeing is a lot of benign notifications being made, such that to guard against the perceived ambiguity in the 17 sectors, as well as the Act itself. So to give you a bit more information on the actual application process itself, I'll hand you over to Donald.
Yeah, thanks, Thomas. So just over the next 10 minutes or so, I'm going to run us through the application process itself, think about some of the key things we need to consider and the sort of information we need to pull together when making an application to the BEIS. I'll then touch on our experience with the process before finally considering some of the wider market trends, including how the government has enforced the regime so far. So looking firstly at making a notification and some of the key considerations there, the first thing you want to think about, and perhaps the most important point, is the timeline. As we'll see, the process itself isn't overly complex, but it can be time consuming. And it's not something that we're used to factoring into a deal timeline. So the first stage is that the acquirer will need to submit the notification via an online form. Upon submission, there's an initial 30 working day period during which the BEIS, more specifically the Investment Security Unit, or ISU, along with any other relevant government departments, will review the notification form you have submitted. So that clock starts from the moment the ISU accept the notification. We'll come back to that point in just a minute. In our experience, this is supported by the published statistics, the ISU will tend to use the full period, averaging around 28 to 30 working days to respond. And that's even when it seems obvious that a transaction isn't going to pose an issue. So even in those cases, you have to factor in at least 30 working days. Most cases are cleared during this phase, you'll be glad to know, but if the ISU decides, having reviewed the notification, to call in the transaction for a more detailed review, then they have another 30 working days from that point to review and make a decision. And in certain exceptional circumstances, this can be extended by a further 45 working days. So that would take our running total to 105 working days to get a final decision. Even then, that's assuming you've provided all the necessary information, and that's a crucial point because the ISU can ask you for further information to support their review. And if they do so, then that 30 working day clock stops until they're satisfied you've provided that information. And in fact, in our experience, that's well, one of the more challenging aspects of making the notification is pulling together all the information that's required. Once the information's there, the form itself should only really take a couple of hours, but the crucial aspect is having that information to hand. So speaking of the form, I'll just move on now to look at the notification form itself and the sorts of supporting information that needs to be included. The key takeaway from this is really just to note that there's a significant amount of information gathering required. That's information both about the acquirer and the qualifying entity or entities being acquired. So that's the structure on screen there. I'll just very briefly touch on this to give you an idea of what needs to be included. Section 1 asks you for the contact details of the person making application and the various representatives and contacts at the acquirer and the qualifying entity. And that includes questions like whether a notification has been made before. Section 2 will ask you to identify the relevant sector. So essentially setting out why you're required to make the notification and what the trigger event is. So that might be, for example, because a shareholder is acquiring shares such that they will now hold 25%, for example, then that would be your trigger event here. Then the key dates, including when the transaction is scheduled to go ahead. Section 3, you're asked to include details about the qualifying entity, and here you'll be asked to provide both pre and post-acquisition structure charts, which can be one of those more time-consuming information gathering processes that I referred to. Section 4 is more information about the acquirer, including structure charts again. And here they'll want to know about all of the directors of the acquirer, including whether any of them are politically exposed persons, and I'll come back to that point shortly as well. Finally, Section 5, just a space to provide any additional supporting information, and you can attach further materials here and make reference to them. So moving on to our experience of how it works. So as Thomas mentioned, we're seeing most lenders taking unperfected share pledges and relying on other security in the security package rather than applying for clearance. But not all lenders. We had one deal where the relevant sector was energy. The trigger event was that the acquirer was acquiring shares such that they would have over 75% following the transaction. And it was decided in that case that we would go ahead and perfect the share pledges and submit a notification. So in our experience, generally the information required is straightforward, and we found that where we've had queries, the ISU have been very quick and responsive, normally responding within 1 day. So we would suggest making use of them to ask any questions. Of course, it's better to do that at this stage rather than have them asking you for further information and stopping that clock that I referred to. So generally a smooth process, but we have picked out a couple of parts of the form that we found in our experience can be sticking points. The first one is structure charts, which you might think sounds straightforward, but they do ask for the percentage shareholding along with the voting rights and the country of incorporation or residence of any shareholders holding 5% or more of the shares in the acquirer. So as you can imagine, for some larger companies, it's quite a lot of information to provide. Second point, coming back to what I said earlier, and that's the information about the board of directors, which must include whether each director is a politically exposed person or not. So the definition the BEIS give of a politically exposed person is typically a non-UK or domestic member of parliament, head of state or government minister and their family members and known close associates. So most firms have KYC checks that cover politically exposed persons, but the definition the ISU provide includes this idea of known close associates of government ministers and MPs, and that may not be picked up by your usual searches. And in that case, you may have to ask each director individually, which again can slow things down, particularly for larger companies. There's no scope in the form there to say, to the best of our knowledge, no. It's just a straight yes or no answer. And these are important points because along with the notification form, you have to submit 2 declarations, one signed by the acquirer and the other by the person submitting the actual form. And in those declarations, you confirm that everything in the notification is true, correct, and complete. And failure to provide that information is a criminal offence. So the inclusion of the word complete there shows that omitting any information can also be considered a criminal offence. So these are just 1 or 2 points to flag. It's the sort of thing that might interfere with that anticipated timeline that you had in mind. So finally, just taking a look now at what we're seeing generally across the market and an overview of how the government has enforced the regime to date. So in June last year, the BEIS produced the first annual report of the use made of the Act, though because the Act came into force in January, it only covered the first quarter of 2022. The first observation is that the figures were below those anticipated by the government, but there are various reasons for that. The government's estimate, since the government made the estimate, there's been some tweaks to the minimum share acquisition threshold. They moved it from 10% to 25%. So that captures less transactions. And it's thought that some of the deals were accelerated so that they completed before the Act came into force. So we would expect these figures to increase going forward. There were only 17 call-ins for full national security assessment and no final orders were recorded. But we know now as well that this is because some of the assessments just simply hadn't reached a conclusion by the time the report was published. And in fact, in the second half of 2022, the government imposed 14 final orders. So that does suggest that the government isn't shy about making use of the regime. Another observation is that the Act has wide application. That's both in terms of geography and in terms of what it considers to be a threat to national security. And a good example of that is there was a transaction where the acquisition of shares in Nielsen, a company based in the UK, but it listed in the US, and it carried out virtually all of its business in the US. And that deal was called an immediately on completion. So Nielsen invested in AI, but it was purely for market research purposes. But with AI being a relevant sector and the company technically being based in the UK, that was enough to trigger a call-in. So there's also been 5 that have been blocked completely. Notably, of those 5, all but 1 have had links to China. So although it's ostensibly geography neutral, it's certainly interesting to note. From a banking perspective, we aren't seeing security transactions being flagged, but this is likely because market practice at the moment, as Thomas said, has been top for unperfected share pledges. So essentially, the market has been avoiding the NSIA regime so far by not perfecting the share pledges. As Thomas highlighted, there are some risks with unperfected share pledges in Scotland, which means this approach isn't going to be wholly satisfactory to some lenders, although that may all be about to change, as Jake is going to discuss next.
Yeah, thanks, Donald. So as we mentioned earlier, thought it would be quite important to touch upon some exciting changes that are going to be coming into Scotland in the foreseeable future under the Moveable Transactions Scotland Bill, or MTB. We expect that these changes are going to help modernise and simplify the application of NSIA to Scottish banking transactions once they've been fully implemented. So just to touch upon it, as Thomas explained, the main reason that Scottish security over shares can cause a mandatory notification trigger is that to obtain the perfected security over the relevant shares, legal title to the shares must pass to the security holder. And it's this process that gives rise to the voting and control triggers under the NSIA that we've mentioned already. So the reforms under the MTB will provide an alternative approach to the existing way of taking security over shares in a Scottish company by introducing a new form of statutory pledge, which will allow for the creation of a perfected security by registration in a new statutory register alone, rather than having to transfer legal title to the shares. And when fully implemented, if share security is taken in this manner, and provided the security document is drafted properly, we expect that the transaction should be out with a mandatory notification regime, and we should start to see the market reverting back to taking fully perfected share pledges. So we've come to the end of the content of our session today. Thanks for listening. Thomas and Donald, you won't be surprised to hear that we've had quite a few questions in the chat bar. So I'm just going to pick out a couple of them. The first one that I thought was quite interesting is about share security. Donald, where there is a syndicate of lenders involved and security is taken or held in the name of the security trustee, in whose name should the application to the ISU be made?
Yeah, so I think just checking I follow the situation described in the question there. A syndicated lend, so you've got a group of lenders and you would ordinarily have a security trustee or agent that would take on all the security on behalf of that group of lenders, which is just more practical in terms of administration. So in that scenario, is it just the security trustee that makes the notification, or is it each individual lender? That's actually a very good question. The sensible answer, I think, should be that it's the security trustee that makes it on behalf of the lenders. And I know the legislation has certain provisions about sharing a common purpose and joint arrangements, which I think you could rely upon to support that view. But there is that other provision in the NSIA that we've actually looked at before about nominees. I think it says where a nominee holds an interest on behalf of another person, it's that other person that's deemed to hold the interest and not the nominee. So I think the ISU could just as easily interpret that to mean that it's actually each of the lenders that has to make an individual application. I think we would hope that's not the case, because that would mean that information gathering burden that I referred to earlier would be sort of even more burdensome. So to answer the question, it's not totally clear at this stage because it is quite new legislation, but these are the sorts of things that as more notifications are made, we're slowly building up a picture of how the ISU is interpreting and enforcing the legislation. So another one that I think we hope to have more clarity on in future.
Thanks, Donald. Thomas, I think this one might be quite a good one for you. So we've mentioned that because of potential delays to completion and uncertainty around the NSIA regime, some lenders are taking unperfected share security. Do we see any benefit in making a perfected Scots law share security as a CS rather than a CP to a financing?
Yeah, so I think it's certainly something which funders are taking under consideration. I think particularly given as kind of Donald saying there, the NSIA regime is starting to bed in a little bit more now, and there's a bit more of a feeling of certainty amongst both funders and borrowers, and that they're better able to understand the regime now. But I think I should, of course, flag that whether it's a CP or a CS, should of course flag that hardening period issue again that Donald and I touched on. And so I think in a scenario where we're putting perfected share security as, say, a CS, for argument's sake, maybe 120 days after completion, taking 120 out of thin air on the basis of the 105 days, which Donald mentioned, or if we say, within 5 business days of receipt of approval, then that hardening period would still run from that period, not from the date of completion, obviously. But yeah, I mean, I think as well that whilst having an unperfected share security means you don't have fixed security over those shares. Donald and I both mentioned about some funders relying on underlying floating security. So the shares which you would be ordinarily pledging in a perfected share security, they would of course still be caught under the floating security. You just wouldn't have a fixed security over them, such that that the shares can be bought and sold, moved in and out of the ambit of the floating charge, and without funder consent. So yeah, I think certainly it's something which we're starting to see. Maybe moving to CS rather than CP, but it's something, again, I think Donald mentioned it there. It's more one that as transactions continue to progress and as they continue to be falling under the remit of the NSIA, that funders are taking under consideration.
Yeah, thanks for that, Thomas. I'm mindful of the time. I think we might have time to squeeze in one more question, perhaps. Thomas, you've spoken today about share security. Are you coming across NSIA issues in other areas of banking transactions?
Yeah, absolutely. Yeah, and I think really that covering the share security today was just because it gives a really good example of why Scottish transactions are falling under the remit of the Act, given that equitable security point. And the share security obviously touches on the transfer of ownership and of voting rights. But the Act NSIA, it also covers entities that don't have a share capital, and so in those instances, the trigger events are actually linked to holding of rights to a share of the relevant percentage of the capital or profits of that entity. So that could then, for example, cover something like an assignation of partnership interests. So in short, yes, the Act can apply to a really broad range of entities, and not just companies which have a share capital, and not just
covered today, or we weren't able to get to your question when going through the chat bar there. You can see our contact details on the slide there, so please just get in touch with us. Okay, thank you.